Do you rent out property? Then this information will surely interest you. Hi, I'm Daniela. I'm a litigation lawyer specialized in civil law. At our firm, we strive to support our clients along with representing them diligently in their legal disputes. So if you are renting out property, whether you're the owner or the lessee, it is in your interest to make sure that you have a sound and solid contract. Now, in this video, we're going to focus on the contract of lease. In another follow-up video, we're going to look at the rights and obligations of both parties, that of the lessor and the lessee. But back to contracts. Now, in Maltese law states that contract of lease, specifically to leasing out property, have to be in writing. Nowadays, these contracts have to have 5 essential elements. Without one of these elements, that contract is considered as null and void. So it is very important to make sure that your contract of lease contains these 5 elements. Now, what are these 5 essential elements? The first one is the property that's being rented out. It has to be specifically stated which property is being rented out. And second one, the use of such property. Is it going to be used as a residence, for commercial purposes, or for both? The third essential element is the period of rent. For how long is this contract going to be valid? The fourth element is whether that period of rent can be extended or not, and if it can be extended, in what manner. Is it going to be automatic, or does there need to be advance notice? The fifth element is obviously what rent is going to be paid, how much and how is it going to be paid, cash, bank transfer, or whatever. Now, if the property that is being rented out is for residential purposes, then a specific law nowadays applies to that rent. And this imposes the inclusion of 2 additional clauses in the contract. The sixth essential element in such situation is whether a deposit has been paid as a form of security. And if it has been paid, what does it cover? The seventh essential element to be included is an inventory. It's a description of how the property is being rented out at that point in time, and the state of the furniture and appliances included with it. So those are the elements that need to be included in the contract. Now, it is very important to state that a contract of lease has to be signed by all the owners of the property. Now, if for some reason there are a number of co-owners or co-possessors and a lease is given out without the consent of one of them or more than one, those co-owners or co-possessors that have not consented to the lease can go before the rent board and ask for the dissolution of that lease based on their non-consent. On the other side of the coin, we find situations where one of the co-possessors or the co-owners is unjustifiably withholding consent to rent out the property. Also in that case, the other co-owners or co-possessors can apply before the rent board to have it authorize that lease if it finds it to be advantageous and that there is no just cause for the opposition of that one co-owner or co-party. Now, whatever is agreed upon, so we have the 5 or 7 essential elements in the contract, and then there are other clauses that can be inserted and agreed upon, such as with regards to noises, with regards to pets, with regards to subletting. Whatever is agreed upon between the parties and constitutes part of the contract is deemed as law by applying for the party. So for the duration of that contract, those clauses have to be adhered to. Then there are 4 grounds which will apply to terminate, to dissolve the contract of lease. The most obvious is that the time period for which the rent has been agreed upon lapses. So if the rent was intended for 2 years, those 2 years have passed and are up, and the parties have not agreed upon an extension. The second circumstance that leads to dissolution is where the parties have reserved their right to dissolve the lease if a particular circumstance takes place. So, for example, the owner reserves the right to dissolve the lease if the lessee adopts pets. If that condition verifies itself, the owner or one of the parties has the right to terminate the lease. However, such right is not automatic, meaning that that party will still have to send a judicial act to inform the other party. The third ground for dissolution is where one of the parties does not fulfill the obligations that the law imposes on that party. So, for example, as we're going to see in another video, the lessor has the obligation to carry out structural repairs. If those repairs are not carried out, the lessee has 2 options. Either push the owner to do the structural repairs, or else ask for the dissolution of the lease and possible damages. Again, in this circumstance, the solution is not automatic, but a judicial act has to be sent to the other party. The fourth ground for dissolution is where the lessee does not pay the rent punctually on time, on the agreed date. Now again, if this happens more than once, the lessor can choose to send the judicial act to the lessee notifying of the intention to dissolve, and the law grants 15 days within which the lessee can pay. If the lessee still does not pay within those 15 days, then the lease can be dissolved. However, the contract of lease cannot be dissolved with the death of one of the parties. So if the lessor dies or the lessee dies, the contract goes on the heirs and is not dissolved. And if the property is transferred, so the owner of the property sells it to another person, that transfer does not lead to the dissolution of the rent because the buyer of the property has to take on the contract originally agreed upon. Now, as always, this video is only intended for informational purposes and is not to be construed as legal advice. However, if you have found this video helpful and the information useful, please do like and share and leave us a comment in the comment section below. Thanks for watching.